Welcome to Let's Talk Native with John Kane.
So, I'm John Kane, and this is Let's Talk Native. I want to talk about the trust doctrine. This racist legal theory is once again born out of the slave era, pre-Civil War time period, and was created by, again, Chief Justice John Marshall, the longest-serving Chief Justice of the U.S. Supreme Court in American history, serving from 1801 to 1835. Now, John Marshall built upon his doctrine of Christian discovery, which basically says that a Christian nation or a Christian people could claim title to the land held or occupied by non-Christians. But Marshall took it a step farther. He actually said that he could equate the discovery of an inhabited land with the conquest of that inhabited land. So in other words, Christians, by virtue of laying their eyes on a piece of land or a people, could claim not only the title to the lands, but conquest of those lands and those people. So it stretches beyond just this idea of claiming lands. Now, he built upon that by doing another kind of legal contortion, which was to suggest that since our sovereignty was necessarily diminished upon discovery, his words, not mine, that he could actually reduce our persons to wards, akin to wards to a guardian. So what he did was essentially said that we were wards of the federal government at some point in his lifetime, in the early 1800s. Out of that is born this notion of the trust doctrine. And of course, the trust doctrine is two parts. One, you cast somebody as the wards of a guardian or a trustee, and then there's the trustee. Now, keep in mind, there are really well-established trust laws in the United States, and a legal trust is one that has a grantor, somebody with the power to create the trust, a trustee, somebody who is given the responsibility to manage this responsibility to a ward or a beneficiary. And that beneficiary may be a child, maybe somebody who is incapacitated for whatever reason, temporarily or forever. And that's what essentially a legal trust in common law is. And that's not what exists here. Here, the United States just decided that we are wards of the federal government based on no legal principle, no trust agreement, no grantor creating that situation, and named themselves the trustee of this trust responsibility or trust relationship. So it is a bizarre creation and one that doesn't really have any legal standing whatsoever. And I want to bring this up because I also want to acknowledge that while this has been treated as a matter of law for centuries now, for over a century. In fact, even with the recent passing of the anniversary of the Indian Citizenship Act of 1924, it's important to note that even when they declared that we were their citizens, that they still were maintaining that we were wards of the federal government. And that still exists today. So I think it's important that people realize not only did they make us their citizens, supposedly, but they had already made us their wards. And, of course, that's not something that we necessarily embrace or recognize. But I think it's important to note that they don't fully recognize it either. And I wanted to read a passage from one of the Supreme Court justices that sit on the court today that not necessarily a champion of human rights, certainly not a champion of native rights by any means. He's one of the conservative justices. But I think he puts real context to this notion that this trust responsibility, this trust doctrine is false. And that it really would not hold up to any kind of legal scrutiny. So there was a case called the United States versus the Hickory Apache, and this goes back to 2011. And this involved a case where the Apache were trying to gain information on a mining contract that the federal government had negotiated on their behalf. And so they were trying to get some of those some of that documentation associated with that negotiation. And the court said, no, you're not entitled to that because that was lawyer-client privilege between the United States and the mining company. Well, the Apache said, yeah, but if the United States is representing us as our trustee, then we are entitled to that information. They said, no. And here's what I have to read. And this is from Justice Sam Alito, trying to explain why this trust responsibility, this trust relationship is not really a trust. And here's what he had to say. He said, as we have recognized in prior cases, Congress may style its relations with Indians a trust without assuming all the fiduciary duties of a private trustee, creating a trust relationship that is limited or bare compared to a trust relationship between private parties at common law. Throughout the history of the Indian trust relationship, we have recognized that the organization and management of the trust is a sovereign function subject to the plenary powers of Congress. So it's their power. Because the Indian trust relationship represents an exercise of that authority, we have explained that government has a real and direct interest in the guardianship it exercises over the Indian tribes. The interest is one which is vested in it as a sovereign. This is especially so because the government has often structured the trust relationship to pursue its own policy goals. Thus, while trust administration relates to the welfare of the Indians, the maintenance of the limitations which Congress has prescribed as part of its plan of distribution is distinctly an interest of the United States. And he goes on, he says, in a case called Heckman, he says, in Heckman, the government brought suit to cancel certain conveyances of allotments of allotted lands by members of the Indian tribe because the conveyances violated restrictions on the alienation imposed by Congress. The court explained that the government brought the suit as the representative of the very Indian grantors whose conveyances it sought to cancel, and those Indians were thereby bound by the judgment. But while it was formally acting as a trustee, the government was in fact asserting its own sovereign interest in the disposition of Indian lands, and the Indians were precluded from intervening in the litigation to advance a position contrary to that of the government. I mean, this is one of the more outspoken justices of the Supreme Court, and he could not have made it clearer that there is no trust, that this whole thing is a fallacy created so the government could assert its power over Native peoples. This is why, just like with the Doctrine of Christian Discovery, we have got to reject the very notion that the United States is our trustee, that we are their wards, and that they should have the power to negotiate on our behalf and to control our lives in any way, shape, or form. It's a lie. They know it. They admit it. And they're almost arrogant about it. And they put it out there as a matter of case law. This is a legal opinion in a case where they denied a native a party, the Hickory Apache, the right to even know what their trustees were negotiating on their behalf, because they aren't the trustees. They are operating with pure, unadulterated authoritarian rule, not based on us being incompetent, but on them being authoritarian. That's why we have to oppose this stuff. So I wanted to give this brief explanation of the fallacy that exists with this notion of us being their wards, them being our trustees, or there being any kind of trust relationship. We've got to stop using the language. We've got to stop talking about the federal government having a trust responsibility or a trust obligation. They have debt. That's all they have. They have debt and obligation, and they probably have some reparations due to us because of the harm and the damages that they've done under this trust doctrine. I want to thank you for listening. I'm John Kane, and this is Let's Talk Native.